Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
All right, we're broadcasting here from Arlington Heights, which is near Chicago, Illinois. Welcome to Win with the Law, the podcast where we dive deep into the world of the law and learn from the experiences of some of the finest lawyers. I'm your host, Gary Newland. For those of you who do not know me, I'm a trial lawyer at the law firm of Newland and Newland LLP. And today we have a special guest with us, attorney Brian Freiman. With years of experience in the legal field, Brian has handled many cases and has a wealth of knowledge to share. The primary focus of his practice is criminal law. In this episode, we will be discussing how to protect yourself when arrested. It can make all the difference in the world and how you handle yourself in terms of getting the most favorable outcome. So without further ado, let's jump right into it. Hello, Brian. Thank you for being here today.
Thank you, Gary. It's really nice to be here today, and thank you for inviting me.
Brian, can you tell me a little bit about yourself?
My name is Brian Freiman. I've had my own firm for over a decade. It's actually getting close to 15 years, although I'm a little hesitant to admit it because that way people know how old I am. I've done mostly criminal defense, a little bit of other things, along with working alongside some non-for-profits like Northwest Compass, which I'm the chair of, and then Illinois Foundation for Justice, which I am proud to have founded with other two lawyers, including yourself.
And Brian, so you're pretty involved in the community. What sort of the foundation and Northwest Compass, what do they do for the community?
So Northwest Compass is a non-for-profit that's based in Mount Prospect that has a couple different programs with all-around service. So the idea is when someone comes in, we just don't help them with one thing, we help them with whatever issues they have. So we have a food pantry, we have a homelessness clinic for teens, we have housing for temporary housing, we have permanent supportive housing, along with a lot of great and qualified social workers to help anyone who needs it. I've been honored to be a part of the organization for a decade, and it's been my honor to be the chairman of the board for 3 years. And it's been wonderful so far. We've gotten to help thousands of people. And on a personal level, I've gotten to run a charity the last 3 years. We've given away over 250 gift cards to local area kids who normally wouldn't get presents during the holiday season. So it's been an honor for me to do.
Brian, thank you for your service to the community. And why don't we get right into it and start discussing why you decided to practice in the area of criminal law?
So when I was in law school, my father owned real estate, and I'm pretty sure he wanted me, and still probably wanted me to do real estate law. But I interned for the public defender's office, and I fell in love. I love the idea of being in court every day. I like helping people when it's the hardest time. It's easy to help people when, they're good or it's something that makes everyone feel good. But a lot of times when people get arrested, it's the lowest point of their life. And contrary to popular belief, it's not all bad people. It's some people who've made a bad mistake or had a bad situation. And it's been my honor to help those people and everyone else who's needed a lawyer. And since I started, I've been doing a sliding fee so I could help people who don't exactly have the same amount of money, but still need representation, because that's an important part of our law and society.
Brian, this is interesting. One of the most common questions I get, it has to do with when talking amongst friends or whatever, that, does a police officer have to read a person they're arresting? Does he have to read their rights or tell them their rights before he arrests them?
So the answer is yes, but. And the reason I say but is because if they don't, the misconception is that the whole case is tossed out. And that's a misconception. The idea of reading your rights is before you get questioned or interrogated, you understand that you have the right to remain silent. So if they don't read your rights or the Miranda rights, the confession or anything you say after that can be thrown out of court. That doesn't mean you're automatically found not guilty, but it does mean that anything after that they haven't done their job can be let go in court. That's the difference. And that has to happen during an arrest. It doesn't have to happen at the start of the stop. It just has to happen during the arrest before they interrogate or question you.
So does Miranda only pertain to statements the arrested person makes?
Any statements or evidence given up after the Miranda rights should have been told, yes.
Okay.
And to be honest, and this is the most important thing, I've always told people a fish gets caught when it opens its mouth. If you're getting arrested, your best bet is to say nothing. There is nothing you're going to say that's going to get you out of it at that point. You need to either call a lawyer, which is number one, or say, I don't want to speak without my attorney. Because once you say that, it establishes a bar for the police where they cannot question you without an attorney available. And any qualified attorney is going to tell you, say nothing, because you're not going to help yourself.
Well, along those lines, what immediate steps should someone take if detained by a police officer?
So if you're detained, depending on if you're driving or not, if you're driving and you're detained, let's say they think you might have had been drinking too much or taking some substance, the first thing you want to do is be quiet. They're going to ask you several questions. Have you been drinking? Have you done any of this? And once you do that, once you talk about it, all but use against you. And you have no need to say anything. You have the right to remain silent, which not enough people do. Your best bet is to say, I want my lawyer. Now, they might ask you to do some field sobriety tests too, especially if it's DUI. You have an absolute right to refuse those. And the other thing to be important of is they're going to ask you about injuries. One of the tests is the walk and turn. So it's steps together right in front of another. I can't do that, not because I've been drinking, but because I had spinal surgery twice. So my balance is affected by that. So if they gave me that test, that wouldn't show anything about my drinking. It would show that I've had spinal surgery twice. But if I don't mention that to the officer before I do the test, they're not going to be able to consider it for any case or trial. It's important to be honest. And more importantly, just say, no, thank you, if you've been drinking or have had any consumption. Because your best bet at that point is to be quiet.
You know, Brian, I can remember a time where I was pulled over by, I would say, an overly aggressive police officer who had asked me if I had been drinking, and I had not. And he asked me to get out of the car, and I cooperated, and I did do the test because I was curious. I was curious whether or not he would administer them properly, because I had heard so many times over the years they're not administered properly. Well, after he administered all the tests, I proceeded to lecture him on how he administered every test improperly. And at that time, I was a former prosecutor and I was doing criminal defense. I wasn't doing personal injury then. I knew the tests like the back of my hand. And after I lectured him on how he administered the tests improperly, he goes, "You're a lawyer. You better get out of here now." But the problem that we have here is it's, most cops are good and trying to do the right thing, but there are those cops that aren't. And that's why people need to protect themselves. Is that correct?
Yes. And the other problem is a lack of training really on DUI, because unfortunately, the only time most of the officers get trained is at the Illinois State Police Academy when they first join up. And the training for DUIs is maybe a day. And it's actually much more complicated than that, because the three primary tests they use, which is from the NHTSA standard, needs to be understood in order to be done correctly, because the first of the couple of tests isn't actually to see if you're intoxicated, it's just to see if you had anything to drink, any consumption. And a lot of officers misunderstand that test. And it's a very basic thing that is important to understand.
I understand that one of the tests he had me do was the horizontal gaze and nystagmus test. Are you familiar
That's
with
the one
test?
yes, that's the one that is only for consumption. So the way it looks is it's looking for an nystagmus, which is a bouncing of the eye. So when they do this and your eye follows it, what they're looking for is a bouncing of the eye over here. Okay, so it's called a resting gaze nystagmus. Your pupils will bounce a little bit if you've been drinking or had consumption. The other way they do it is the vertical, which is like this, and that's supposed to test for marijuana consumption, although the scientific test on that has been, let's say, 50-50 at best. And the common misunderstanding is that proves they're drunk, and it doesn't. If you've had one beer, which is not over drunk, not over 0.08, you would still fail the horizontal gaze nystagmus. But it doesn't mean you're intoxicated. It means you had anything to drink. And that's a quite common misconception.
In my situation, the police officer administered the test with oncoming traffic coming, and he left his cherry lights on. And that would cause a nystagmus in anyone. Is that fair?
Yes, it's also going to affect your pupil dilation and your ability to follow the finger, because a light shining directly in your eyes interferes with anything else you're trying to see, as most people probably know. And it would be almost impossible to do. And a very common mistake for officers, especially at night, is that they shine their lights directly on the person's face, therefore making it very hard to actually do the nystagmus test.
Brian, when does your role kick in?
So I've had clients, if the clients are smart enough to call me the moment they have a problem, I go to the police station right away. I've done it many times. It's a lot of times that I've been able to help the client either by making sure they don't say anything that hurts them so we can do better at trial, or they don't admit something so the officers do not have enough to charge. And especially with felony cases, because in a felony case in Cook County, in order for the officer to charge a felony, it has to go to what's called felony review, which means a state's attorney has to approve it. It means there has to be enough. So a state's attorney will be objective and look at the facts. And if there's no confession and they can't show that there's enough there, they won't be able to charge that felony. So I've had many clients who've been able to get out of getting charged because they have been simply had a lawyer there and they said nothing, which is very important.
And when you're there, you're protecting the integrity of the process is what you're doing, correct?
Yes, and defending my client. This is the most important thing, is my job is to defend the person because they have the constitutional right. It's a controversial subject, but the bottom line is the way our Constitution works is there has to be checks and balances. Part of that is making sure I'm doing my job so the officers do their job. We always see that the officers, they're doing something they're not supposed to. Well, that's why a lawyer comes in to make sure that they're following it. If I don't do my job correctly, an officer could do whatever they want, and that's not acceptable. And although I understand people might have a moral issue with it, it's essential to make sure that the people have the right lawyer and their rights protected, because without that, we will not be able to have a free society like we do.
Brian, you mentioned the term felony. Can you explain the difference between a misdemeanor and a felony?
Of course. So felony is any crime punishable by over a year in jail. So one of those would be a murder. Murder is punishable by a year in jail. The other one of those could be possession of cocaine. Now, those are not on the same level, obviously. No one's going to jail for 50 years for possession of cocaine, hopefully. But those are both considered felonies because the possible sentence is over a year in jail. A misdemeanor is anything less than a year in jail. So a battery, a DUI might be a misdemeanor. There's actually a third category called petty tickets. And petty tickets are like speeding tickets. So if you're going 10 to 15 over, that's a petty ticket. And the reason it's called a petty ticket is there's no jail time attached. If you're going 15 miles an hour over, you can't go to jail for that. Now, unfortunately, if you're going 26 miles an hour over, that becomes a misdemeanor if you're speeding that high. And you technically could get a jail for that, and you will need a lawyer. Whereas petty tickets, you do not need a lawyer because there is no jailable time attached. You must and you should have one for a misdemeanor and a felony.
So, Brian, is the process different when you go to court for a misdemeanor versus a felony?
It is a bit. A felony is going to have a little bit more discovery. So with the felony, there's also additional steps, and I explained that. Every felony, you not only have a bond hearing, which is a hearing to see if they'll get out. In misdemeanors, usually the police station will let them out on an I bond or some kind of small amount of money. but they can do it from the station. Any felony needs to be bonded from court, so you'll see a judge and get bonded that way. Also, felonies have what's called a preliminary hearing or grand jury indictment. And the idea is to make sure there's enough to charge, because it's a serious crime. You're looking at a year in jail. You don't want that falling through the cracks. So in order to do that, Illinois law says that either they must have a preliminary hearing, and a preliminary hearing is a hearing in front of the judge with the officer or the complaining witness, and your defense attorney gets to question them too, and the judge sees if there's enough to charge. Not if you're guilty, but enough to charge. And the other way is called a grand jury indictment. And a grand jury is just 16 people with only the state, and they decide if there's enough to charge. So this defense attorney can't be there, the defendant can't be there. It is literally the state, 16 people. And there's an old saying in Cook County will indict a ham sandwich. So a lot of things will go to grand jury because maybe they don't want the officer questioned, or it's not as strong a case as they would like in a preliminary hearing.
Okay, and so grand jury or preliminary hearing are required if there's a felony in Illinois. Is that correct?
Yes, and it's not required for a misdemeanor because of the lesser sentence.
Okay. And the lesser sentence is less than a year in jail. Is that correct?
Yes.
Okay.
Punishable by up to a year in jail. Not every misdemeanor is a year in jail.
Now, where does a DUI fit into misdemeanor versus felony?
So DUIs, if you're first or second, is usually going to be a misdemeanor, unless you unfortunately hurt someone or there's other factors involved, including you don't have a license, don't have insurance, and some other factors. So most first-time DUIs are misdemeanors. Now, on the one thing everyone asks me with DUI is about their license, because it's one of the rare criminal cases that kind of deal with both. It's not only criminal, it's a little bit civil, because technically your license is a civil issue, but you can't just ignore it as a lawyer. So because when you get a DUI, your license gets suspended after 45 days. A lawyer can file what's called a petition to rescind summary suspension to try and get it back. And the reason to do that is because you want to get your license back if you can. And the lawyer has a few options. One of the things that you'll look at is, did they read the warnings to motorists? Did they tell you that if you don't blow, your license is suspended? Also, is there enough to arrest you? Should you have been arrested in the first place? Did they have any proof that you had committed a crime and should have been arrested? There's also a couple other reasons, but if they can't prove that, or your lawyer can prove that that's not true, you can get your license back right away on a DUI with a petition to rescind summary suspension. But technically that's civil. As for the criminal penalty in a DUI, the first DUI is usually eligible for supervision, unless, again, there's a problem. Supervision doesn't go in your record as conviction and won't affect your license. On your second DUI, however, you cannot get supervision again by law. So you must have a conviction, and then a conviction automatically revokes your license, which means if you'd like to have it back, you'll have to have a hearing with the Secretary of State after a couple of years after you've completed all of the classes, all of the things, and shown the court that you've done what you're supposed to.
So if you're not successful with rescinding the summary suspension, the person will lose their license for how long?
So if you blew over, it could be 6 months. If you refuse to blow, it could be a year. However, my advice is not to blow, because it's better to win your DUI and lose the hearing than to lose both. Now, the other thing is, you don't automatically lose your license. You can get what's called a BAID, or MDDP. So that's more commonly known as the blow device in your car. So they install it in, and anytime you want the car to start, you have to and make sure there's no alcohol in your breath. And you get that option. So anyone gets that option on their first DUI. So even if you don't win the petition or rescind summary suspension, you have an option to drive as long as that's in your car. Now, I want to say something. I had a client this happened to once. Do not let anyone play with that device. I had a client whose friends thought it'd be hilarious to see how much they could blow in and how high they could get it. It was cute until I had the judge asking me why there was a blow of 0.24 on the device and why we should let him have his license. So it's important when you have that device in your car, it is the only car you can drive, and you must make sure whoever uses that car is going to have to use that. They cannot play with that device.
So it keeps score, is what you're saying.
It does. It does. And the Secretary of State can access it. That's why you have to upload every few months.
Okay. Well, that's good to know. Now, with respect to DUIs, what do you recommend someone do in terms of communicating with the officer upon being pulled over?
Don't be rude to the officer. The biggest thing is they're doing their job. Okay. I understand the reputation of officers, but every job has a few bad apples. Lawyers, officers, most of them are good. Try and be pleasant. Remember, this is their job. But it is not your job to incriminate yourself. If they ask you, have you been drinking? You do not have to say yes or no. Now, you don't want to lie to the officer, but you can absolutely say, I want my attorney, I'm not speaking without it, or I plead the fifth. My advice is, if you have consumption, drinking, or whatever, be polite, but if they ask you about that, ask for your attorney. And if they ask you to do the test, say, no, thank you, I want my attorney. Because at that point, any test will be used against you.
What if they tell you to get out of the car?
You need to comply. That's a basic thing, is you need to comply. Getting out of the car, they have a right to ask you. Now, if you don't want to do the test, they can't force you unless they have a warrant. So the other thing is, a lot of times they'll say, okay, we want to take your blood. That's not required. Unless there is literally something signed by a judge saying that they can do it, they can't do it without permission. And you do not have to give them permission no matter how much they pressure you. You have absolute right to say no. And that's the thing I think people, the misunderstanding is, you have a right to say no, but you can also do it politely, whereas some people aren't as polite, let's say.
Isn't it true? So now most police officers, or many, I should say, are wearing body cameras. Is that correct?
Yes. And I
do
think
those
that's
body cameras also record?
Yes, they do.
Sound?
And it's,
Okay.
yeah, it should, yes. And it's better because a lot of times I've gotten officer reports and then I get the body cam and let's just say they don't match up.
Yeah.
The body cam gives an actual showing of what happened, as long as the officer uses it correctly. And if the officer doesn't use it correctly, there's a motion that we can file to try and eliminate all testimony about what should be on the camera if the officer didn't use it, and the department has a mandate. So it's actually been a better thing for law and for lawyers because it makes it a clearer case.
Yeah, it seems to protect the police as well as the people being arrested. It's do you feel it's advantageous?
I think it's advantageous for the general public. They always had squad cameras, but my issue with squad cameras is the police can just go out of the range of the squad camera. They know the range of the squad camera. If they don't want something on video, they just go out of range of the squad camera. Whereas
squad, you mean a camera inside the vehicle itself?
Yes, thanks.
Okay.
Whereas a body cam is attached to them, so there is always recorded evidence of what happened, whether good or bad, whether the office, if you said you did something and you didn't, it's there. If the officer said you did something you didn't, it's there. So I much prefer that.
And with respect to the police, overall, you commented how, most police are good and trying to do the right thing, I think is what you're saying. What does someone do if a police officer is acting abusive? How did they handle that situation?
First, if they're going to arrest you, they're going to arrest you. Do not resist because you will have another charge. You have to let them arrest you. However, you have no need to give them any information. If you say, I'm not speaking without my attorney, and they keep asking you, you have every right to say, I'm not speaking to you. So you should be firm in that answer. And my advice, and the advice I give all my clients, is call me right away. I don't care if it's 3 a.m, call me, because that way I can ensure what's going on is fair. Always be polite, but you have to be firm because you have to know your rights and you have to protect your own rights. And that's your job. And that's more importantly my job. So like I said, if the officer wants you to get out of the car, you're going to end up getting out of the car. If he wants you to do tests, you have absolute right to say no. Now, he might try and cajole you or intimidate you or get you to do the test, but he has no right to make you do it. So if you say no, the answer is no. Whatever comes out of him, just keep saying no.
Why do some people do judge trials and some people do jury trials in criminal law?
So for me, I think there's a couple considerations. First thing is it's always the client's decision. There are three things that every client can decide whether I think so or not. One is to plead guilty or not guilty at any time. Second is if they want to bench or jury or judge or a jury trial. Jury is 12 people that listen to the case and decide if you're guilty or not. And the third thing is if they want to testify. I think for me, there's two factors that go into a jury. The first thing is, how's the judge? Is it a good judge to do a trial in front of? And the other thing is it the law or is it an emotional case? A law-based case is sometimes harder with the jury because it requires intimate knowledge of the law. So that might be harder to show a jury, whereas hopefully a judge has already had that knowledge and understands it. Whereas if it's more an emotional case, it's sometimes better for a jury because a jury will understand emotions and there's 12 people there who can really understand what's going on and can talk about it. But at the end of the day, it is absolutely the client's decision. I just make a recommendation either way.
So is it fair to say that some judges are more conservative or like to find more people guilty than some other judges in your experience?
Absolutely. And the biggest thing is people, and I think I didn't really understand this when I was in school. You always think, oh, the judge is this revered person and above it all. And at the end of the day, they're actually just humans and humans with experiences and opinions. And even if they don't let them known in court, your opinions will reflect on how you rule or how you do anything and your interaction with humanity. So a lot of judges, they're human. They're good and bad, just like officers. So there's definitely some judges that I prefer to go to trial with. And there's some that, let's just say, it's almost always a jury.
I can remember when I was prosecuting, and every once in a while a police officer would say to me, that defendant really gave me a hard time. He was really difficult. And as a prosecutor, I would pay more attention to those cases. And is that one of the reasons you advise people always be polite?
It is. It's also for human decency purposes. But yes, look, if you do something wrong and we need to negotiate a plea or something like that, it is really going to matter how rude you were to the officer. If it's over a year later from the incident and the officer remembers you because you were that rude, that's not a good thing. Okay? Most people, they forget because they do, a couple DUIs a week or whatever it is. So in order to stand out, something really off had to have happened. And let's just say it's sometimes like a teacher in school. If they know your name, it's because you're the best in class or the worst. There's no in between. So it's kind of the same way.
Well, what's something someone can do once they're being pulled over and they're concerned, because we've seen many things in the news about how people have been shot by police and how things haven't gone right. How should the person, what should they do with their hands as the police officer is approaching the car?
You want to have your hands visible because one of the scariest things is that for an officer is walking into an unknown situation, whether in a car, in a house, or anything else. So being able to see your hands makes it easier for them to know that you don't have anything. And the other thing is, if you have a concealed carry permit, if you have a weapon legally held, or if there's a knife next to you, you want to let the officer know. Because what you don't want to do is surprise the officer with a gun or any weapon like that. If it's illegal, don't confess to anything. But if you have it legally held, you want to let them know. The other thing is, when you're talking to the officer, try and look at them. A lot of people like to look away. And one of the things people don't know is psychologically, looking someone in the eye actually helps you because looking someone in the eye shows your confidence and your honesty. Whereas if you look away, it takes away and it kind of looks like you aren't being serious or honest. So one of the things is to actually acknowledge and look the officer in the eye and comply with it. If he asks you out of the car, get out of the car. You have an absolute right to say why, but you need to comply with it.
The officers, most of the time, they're just trying to go home to their family eventually and their shift is over. Is that correct? And that's what they're thinking. How do I get through this shift without getting killed?
Absolutely. And I know many officers who were disgusted with what happened with George Floyd. I know many people, and it is disgusting. Make no mind. And it's unfortunate that still happens. But most officers feel the same way most people do if this is not acceptable or okay. It's unfortunately a very small percentage that do it. And the hard thing is that when you have that kind of power, if you have no moral compass, it's easy to take advantage of. But most officers, they want to do good and they want to help. And I've talked to officers and I get along with them very well. Now, however, once you get to stand, you're mine, so I got to do my job. But they understand that usually. Some get mad, but I won.
Well, you're just making them accountable that they do their job properly, and that's good lawyering.
I want to plug Illinois Foundation for Justice, which Gary had a hand in starting and I did. As I said before, we got 250 gift cards out. That was thanks to Illinois Foundation for Justice and the work you've done. And something we want to be continuing on during the new year because it's important to me and I know it's important to you for lawyers to give back. We're very lucky. This is a good job. We understand how lucky we are and we want to help the community because we are part of it. And when we started this foundation, I know you feel the same way. That was a big thing is we are here for the community. Being a lawyer, especially criminal defense, is you interact with people and you understand the stories and you're sympathetic and you're empathetic to them. Because again, usually you see people at the worst day of their life. And that's really hard. And you have to understand that this is important. I've always said for me, the day I stop understanding it's a person, the day I quit. Because every case has to be important. You're not flipping a burger. This is someone's life. I'm very lucky to do this, but again, it is very important that I do a good job for my clients because they pay the consequences, and I am not willing to let anyone pay any consequences because of my actions. My job is to do the best I can. And the Illinois Foundation for Justice really allows us to pay back community for what they've given us. And I'm very honored to be a part of it and to be with you on it.
Thank you, Brian. I appreciate that. And as a member of the community, I appreciate everything you do. The legal community in the northwest suburbs of Chicago, where you have made a big impact. Appreciate it.
You have also too. I don't think anyone knows this, but you have done an amazing job. And there are lots of people out here who wouldn't be in the same situation without you, including me. So thank you.
Brian, thank you. And I want to thank you for being here and talking to our viewers. And we're signing off from Arlington Heights, Illinois.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.